All right, good afternoon, everyone. It is 12 o'clock, so we will get started with our February edition of In the Boardroom with Andy Phillips and Attolles Law, brought to you by the Wisconsin Counties Association. I'm Sarah Deidre Kasdorf, Director of Outreach and Member Engagement at WCA. It's my pleasure to welcome you to this afternoon's webinar. As I sit here and think about this, Andy, you can correct me if I'm wrong, but I believe we are at the 1-year anniversary of In the Boardroom. I think our
The
first In the
inaugural
Boardroom was
edition, yeah.
February of 24 or 20.
That's right. We were talking about renewable energy at February edition 2023, and we've progressed all the way to the organizational meeting. How exciting is that?
That is exciting. And as Andy mentioned, of course, this afternoon, we are discussing a topic that all county boards across the state will be participating in on April 16th, and that is the county board organizational meeting. Now, to ensure that we have enough time to get through all the materials that Andy and Rebecca prepared for today, I'm not going to talk about our topic introduction, but instead just take a moment to remind you that if you have any questions during the webinar, please feel free to use either the chat or the Q&A feature of Zoom, and we will be monitoring the questions throughout the webinar. But to make sure that we get through all of the slides that were prepared for today, if necessary, we may need to wait to hold some of the questions until the end. But this webinar is being recorded and will be placed on the WCA website shortly after its conclusion today. So with that, I'm going to turn the program today over to the namesake of the series, Andy Phillips, and his colleague, Rebecca Roker.
Thank you, Sarah, and good afternoon, everybody. As Sarah indicated, this is intended to be a virtual discussion, not necessarily a presentation. So if you have questions or comment, please put them into the Q&A or chat using the button features on your screen so that we can address those issues. Today, we're going to talk about the organizational meeting. As Sarah mentioned, that's something that's coming up literally in 2 months, less than 2 months. And so I think a lot of counties are going through right now preparations for that organizational meeting. We're going to cover topics about what are the statutory requirements associated with the organizational meeting. And I'll let you know a little secret here, there aren't many. But then talk about how do you establish the organizational meeting as a platform for success within your county. I know that Rebecca and I have both been all over the state as it relates to counties and their boards and the organizational processes those boards follow. And our intent here is not to tell you exactly what you must do or what you have to do to be legally compliant, because of course, 59.03 of the statutes, which I often refer to as the Freedom Statute, provides counties with administrative home rule authority to organize their affairs as they best see fit. So even though all 72 counties are governed by Chapter 59 of the statutes, all 72 counties have a different way of doing things, and that's okay. And that's actually good because it reflects the values that are prevalent in the community where the county is. That said, I think that this is an opportunity to maybe plant a seed or two about how can we maybe change some things, update some things, make things better. And that's the intent of today's discussion, is how do we get through this organizational meeting in a way that establishes that platform for 2 years of success between 2024 and 2026. So anything you want to add at the outset, Rebecca, before we get going on the slides themselves?
No, thank you, Doc.
All right, you bet. So without further ado, we have the county organizational meeting. There is one statute that deals with the organizational meeting, and it's strange, and I want to talk about its oddities here for a moment. The statute itself says that the county board, excepting counties with a population of 750,000 or more, and that's Milwaukee County, shall meet, not can meet or may meet, but shall meet on the third Tuesday of each April. Okay, it doesn't say every 2 years. It doesn't say an even numbered years. It says each April to organize and transact business. Now, I say that, and I've added emphasis there to each April, because I want to highlight how the statutes probably haven't kept up with the times. In that same statute, 59.11, there's reference to an annual meeting, and the 2 meetings that a county has to have every year are an organizational meeting and an annual meeting. And then if the county wants, it can meet more times. The board can meet more times. We know that in every county, you meet more than twice per year, but I think the statutes were written long ago to ensure that county boards were getting together at least twice a year in order to organize, transact business, adopt a budget, levy a tax. The adopting a budget and levying a tax happens at the annual meeting. So When we look at this as a shall, so it's an imperative from the legislature, we meet on the third Tuesday of each April. Are we required to meet every year on the third Tuesday of each April? It would be my impression that, again, 59.03 allows us to modify this schedule so long as we have a meeting biennially every 2 years to organize ourselves. And we'll get into what organizing actually means. So I think it's okay that we don't have an organizational meeting every single year. In fact, it makes a lot more sense for the new board. All of the new members on the board and the returning members who are elected again get together and speak to this concept of organizing how they're going to govern themselves over the course of the next 2 years. So again, the bullet points at the bottom, required to meet on the third Tuesday of April. The meeting can be adjourned to a different date. That's important because there may be some business that occurs at the organizational meeting that is carried over to the next meeting. We'll talk about that in a minute. And it's a very simple purpose within the statute. That's to organize and otherwise transact business. It's important that transact business is in there as well, because the organizational meeting does not have to be solely devoted to the organization process. If there is an important item that needs to get before the county board, that item can be on the agenda for that organizational meeting. That's okay. Typically, at an organizational meeting, we have the election of officers, and the two required officers in statute are county board chair and county board vice chair. The statute that governs those officers' election is 59.12 of the statute. The statute does not tie the election of those officers directly to the organizational meeting. The statute simply says it's the first meeting after each regular election. Now, as a matter of practicality, I think the first meeting after a regular election is the organizational meeting, but I think you have to keep that in mind when you're looking at your county board calendar to make sure that the third Tuesday in April is the first meeting after the election of the new members to the board. And so for all intents and purposes, what I have seen in every county, and somebody can correct me if I'm wrong, but in every county, we have the election of officers on the agenda for the organizational meeting, okay? So again, when we look at what is required in terms of the election, it's very simple in terms of the statutory prerogative, shall elect a member chairperson. So we have an imperative. We must elect a member chairperson, and that person serves until the board elects a successor. There's an attorney general opinion from, I believe it's 2006 or thereabouts, which speaks to this concept of the board having the ability to, at any point it wants to, elect a successor board chair, and that's fine. So in other words, it's not necessarily a 2-year term with no ability to elect another person to that office, but it's until the board elects a successor, okay? And then 5912 sub 1 provides some additional duties for the board chair. At the same time that the board elects a board chair, a board can elect a vice chair, and it has to elect a vice chair, and that vice chair serves in the absence of the board chair, okay? Now, 5912 doesn't speak to other potential officers of the county board. And what I mean by that is that the board is free to establish the office or position of second vice chair, sergeant at arms, or whatever else the board desires in order to govern itself. Those positions should be established in your board rules, and the election to those positions should happen at the same time that the chair and vice chair are elected. It's just the statute doesn't recognize an imperative that you create those positions, nor do the statutes require that you have that election at that organizational meeting when you elect the chair and vice chair. That said, it makes a ton of sense to elect those positions at the time that you elect chair and vice chair. Before moving on from this, I want to back up a moment and take a look at 5911, because the text of the statute says that every county except for Milwaukee County has to organize and transact business in the third Tuesday in April. And people say, well, what about Milwaukee County? What's the statute that applies to them? This was a curiosity that Rebecca and we crawled down several different statutory rabbit holes over the course of the past week, trying to figure out exactly why Milwaukee is exempted and what statute applies to Milwaukee. There's no statute on the books that applies to Milwaukee, but Milwaukee County does have an ordinance requiring an organizational meeting. And so all I can think is that at the time that the legislature enacted the statute, the Milwaukee County ordinance already provided a process for the organizational meeting that they didn't want to upset as a result of enacting this statute. And again, the statutes have not necessarily kept up with the times, so to speak. And so it's not surprising that we would have certain gaps within the statutory framework. All right, we've got a couple of questions already, and maybe I'll address those here because they deal with the timing. The statute says at the first meeting after each regular election means after they are seated, correct? We typically have 2 meetings between the spring elections and the new board being seated or sworn in. That's a great question. The statute does not specify whether the new county board members need to be seated. But before those county board members are seated, a very important act has to happen, and that's administration of the oath. There's a written oath and a verbal oath. And so the person that is elected does not have the ability to fulfill the duties of the office until such time as that member is sworn at oath to uphold state constitution, federal constitution, and the laws of the county. And so it would be my impression that even though the statute says it's the first meeting after each regular election, that refers to when the person is seated, because up until that time, they're not eligible or able to fulfill the duties of county board supervisors. So that's a great point, Joe. And again, further illustration of how the statutory language has not necessarily kept up with the times. Another question here, is there a statute or parliamentary procedure to call for the election of a successor chair if the intent is to remove a sitting one, as opposed to filling a vacancy? Mike Wendell notes that the current board rules assign responsibility for agenda preparation to the chair, and you could see a sitting chair being unwilling to entertain that particular agenda item. And Mike, I get that question an awful lot. The parliamentary procedure, of course, is that at the end of a meeting, a member of the board would ask that the election of chair be placed on the agenda for the next regular meeting. And if the body agrees with placing that item on the agenda, then the chair has no choice. The chair has to put that issue on the agenda. What I would prefer, and I think what Rebecca would prefer, is that we spell out that process in the board rules. And I'm not talking simply about the process for getting removal of chair on the agenda. I'm talking about the process for getting items on the agenda in the event the chair simply refuses to place an item on the agenda. We spoke about board rules a couple of months ago, and I think it's really important to understand that the board rules work hand in glove with the organizational meeting, because the process of electing officers, the process of potentially electing replacement officers, the process of setting the agenda, all of those things are items that you can and should address within your board rules. That way, you don't have that question of how does something get on the agenda, because if you turn to parliamentary procedure, it's less than helpful in specifying exactly how that happens, but you have it spelled out in your board rules, and those are the rules that everybody follows. We have another question as it relates to Douglas County. They're planning on a regular monthly county board meeting on April 12th, and the organizational meeting is on the 16th. Per the statute, we should be having the chairperson election on April 12th because it would be the first meeting after the election. And I want to clarify that, Casey, that goes directly to Joe's earlier point about what does it mean at the first meeting? Because we have a bunch of people who've not been sworn on oath, administered that oath. They can't serve as supervisors until that oath is administered, and it's not administered until we get to the organizational meeting. And so it would be my impression, again, understanding that the statute isn't exactly clear on this, that we do not have the ability to have the organizational meeting until we have supervisors that are sworn on oath. And so until that time, the old board, so to speak, takes action, if that makes sense. All right. Committees and committee assignments. Again, the statute says that the chair, if authorized by the body, can appoint committees before June 1. It doesn't have to happen at the organizational meeting, but as a matter of course, many counties do have this occur at the organizational meeting. A couple of important points here from my perspective. How does the committee appointment process work in your county? Is that prescribed in your board rules? I think, again, that this is a very important topic to place into your board rules so that the entire board has an understanding of the process for populating committees, an understanding of the process for designating chair and vice chair of those committees, and then designating the process for removal from committees or removal as chair or vice chair of those committees, all right? The board rules can fill in all of those gaps. And 59.03 of the statutes allows you as a county board to administer your internal affairs the way that you best see fit. So if you want this all to occur at the organizational meeting, great. If you want the process to start at the organizational meeting and finish at the subsequent meeting, great, you can do that. The statutes say that it has to happen before June 1. I'm not aware of any county that takes longer than June 1 in order to accomplish that task. May happen, but I just don't typically see that. The reason I don't typically see that is that there are all sorts of things going on within the county that need to be done by June 1st. If we waited until the end of May to appoint committees, we would be going on 2 full months without committees. I think there's a lot of important work that committees do in that 2-month period. And so we want to make sure that we are diligent in making sure that we have persons seated on those committees. We have a chair and vice chair of those committees, and those committees can then commence doing the very important business that they need to do. The other bullet point that we have on this slide, somewhat related to committees, somewhat not, is how are executive or administrative appointments handled? The reason I ask that is if you look at 59.17 and 59.18 in the statutes, for those counties with an executive or an administrator, we know that the executive or administrator makes appointments to boards and commissions subject to board confirmation. Again, a good topic for your board rules is to establish the process for the administrator forwarding an appointment to a board or commission subject to board confirmation, and then a process for the board to consider that appointment. Again, I think it's important that that process be expedient because we do not want vacancies to linger for too long of a period of time. And we also want to avoid any confusion about that process. All this means is that it's a great topic for your board rules. All right, Rebecca, I've been talking for a while. Anything that you want to add on any of the discussion points thus far?
Not necessarily add to, but, well, maybe. Hi, everyone. Great to be here. Great to see everyone virtually. You mentioned the importance of the board rules, Andy, and that's a consistent theme that I see throughout counties. Given that power that counties have under 5903 to develop the board rules and really make them particularized as to how that board wants to see its operations and functions flow, I think is a great part of our statute. And so the importance of those board rules, I can't overemphasize too much. And not only at the organizational meeting, but it never ceases to surprise me how often the board rules will be referenced at any given meeting. And so, yes, they are certainly important for, items like the committee appointments and, election of officers to supplement what we already are required to do in the statutes. But even just basic procedural items that, may be particular to your county or you want to have clarity, or you can put those in the board rules, and those can be referenced at every meeting. One other item with respect to the portion of 5913 that you referenced, Andy, and the appointment of committee members. I was just looking through the statutes to see if I could locate anything that requires any sort of monthly action by a standing committee. And I didn't locate anything, but that's something to keep in mind, depending on your committee work. If there's something that must be approved before June 1st, or you have to do something before June 1st, make sure your committees are appointed, because obviously you need to have a committee to take those actions.
No,
You can think of anything.
no, I mean, but I know there are things that are going to come up. I think about the Highway Committee, the Human Services Committee, the board, a zoning committee. I mean, there are things that are going to come up. And I think that the flexibility in 59.03 that you mentioned is really important because, for example, with the Highway Committee, In the absence of the county board creating a different process, you have to elect your highway committee members. And so there are many counties out there, I know, that think you are required by 83.015 to elect your highway committee, and that's just not true. The statute allows a county to designate a different process for populating your highway committee. It doesn't have to be by election. If you want an election and you like an election, go for it. You can do that. That's fine. And by the way, that cannot be by secret ballot, as we'll get into in a moment. But you can elect your highway committee if that's what you want to do. But if you want to take your highway committee and slot them into the other standing committees and populate that committee the same way that you populate the other standing committees, then you absolutely can do that. That's allowed by statute. So again, all of these things can be contained within your board rules so that you reduce anxiety on the part of the board about what happens next. Well, we know what's going to happen next because we have that process laid out in our board rules.
Mhm. Yeah, good point, Andy, on the highway committee. And it just occurred to me too that a zoning committee certainly may have things that are very time sensitive. There's certain provisions of the statute that require the county to take action within a certain period of time, and that certain period of time may occur closely after the election. So counties should always be mindful of those important dates that they're bound to take action on.
So we know we have to have an organizational meeting. We have a good idea of what we need to accomplish within that organizational meeting. So we're going to prepare an agenda for that meeting. When we prepare an agenda for that meeting, we should not be starting from scratch. We should be taking a look historically at what we have done at our organizational meeting in years past. Doesn't mean we can't modify, supplement, delete, but take a look at, again, what the regular process is in your county for the organizational meeting and base the agenda off that. It promotes regularity. It promotes understanding on the part of the community about what's going to happen at that organizational meeting. And so we want to prepare this agenda, and this agenda is going to serve as a foundation for future organizational meetings as well. What we have listed here on agenda preparation, you can modify this, obviously, but I think that there is a certain pomp and circumstance that belongs at the organizational meeting. Why is that? Because of the third bullet point here, administration of the oath of office. This is a big deal. This is somebody who is elected to represent his or her constituents on the county board. This is a big deal. So let's add a little pomp and circumstance and ceremonial flair to this organizational meeting. So we have oath of office there as the third bullet point. Invite the community, invite family members, invite others, and treat it as important as it should be. After we administer the oath of office, we need somebody running these meetings. And so let's elect officers, chair, vice chair, and any other officers authorized by the board rules. We either review rules that have been established or we adopt the rules at the organizational meeting. That's important because we want to understand what is the framework of guidelines that we're going to govern ourselves under. Let's have an understanding of those board rules. Then we get into the question about what is the process for committee appointments? Do we take that up as an agenda item at the organizational meeting? Is this something that the expectation is the elected board chair is going to make committee appointments either subject to board confirmation or not subject to confirmation? Again, depending upon how your county does this, you may want to put committee appointments on the agenda. Education. What does that mean? Well, what is it that we think is important for new board supervisors, or for that matter, returning board supervisors, to know when they take a seat on the county board? And so the organizational meeting presents an opportunity to, again, lay the foundation for success. We'll talk a little bit about education more a bit down the road. And then we may have business items that we need to address. Remember, the statutes allow us to transact business at the organizational meeting. And so we may have actual items of business that we need to address prior to adjourning. So again, this agenda is not anything that is required by statute. It's not in any particular order. You can certainly feel free to shuffle, add to, supplement, delete from, whatever. But if you look at all of the elements here, I think this hits the elements that we would have in terms of both statutory requirements and expectations for that organizational meeting. All right, so we've done the preparations for the meeting. Now we get to the meeting itself. And one of the very important tasks that we have discussed relates to electing a board chair. And if you remember from the sample agenda that we just talked about 2 slides ago, we don't elect a board chair until we get down to bullet item 3 or 4 on that agenda. So the question is, who sits in the chair's seat until we get to that item 4 and a board chair is elected? The statutes don't specify who chairs the meeting. If you go to Robert's Rules of Order say that somebody can chair with the consent of the body. So if 51% or more of the board agree with somebody chairing the meeting, that person can chair the meeting. As a practical matter, I don't like leaving it up to just whatever everybody decides at the meeting. I would like to have a presumptive chair walk into that meeting, assume the seat, and make sure there's no objection to that person assuming the seat of chair, but let's not leave it up to the entire body to just decide on a whim. Why? Because that takes time, and there is just precious time that we are wasting on that we could be devoting to other really important tasks at that organizational meeting. So who can chair the meeting? You could have the current chair run the meeting if the current chair ran for re-election and was elected. We could have a former chair that was defeated or did not run for office. We could have a vice chair or second vice chair. And then I like actually the next 3 bullet points, because the next 3 bullet points are persons that are completely disinterested in this process. Your county clerk, your corporation counsel, or another trusted individual cannot run for county board chair, all right? And so there is no interest in trying to rig an election or anything like that. Not that anybody else would do it, but it takes that completely off the table. And so I like having either the county clerk, corporation counsel, or some other trusted individual run that organizational meeting. I can tell you from my personal experience, I think that I have chaired 5 or 6 different organizational meetings in my tenure, and it was fun. I had a great time doing it. It was a blast. But there was no indication that I had some sort of bias or anything in running the elections or determining the order of nominees when they get to speak or anything. I didn't have a horse in that race. And so it was easy for me to chair that meeting without somebody suggesting that I was doing something that would be untoward the county board as it relates to fairness and equity. So whatever your decision, and it is your decision, go ahead and make that decision in advance. And when that person who is the presumptive chair walks into the meeting, sits in the chair's seat, the first thing out of his or her mouth is there any objection with me serving as chair for purposes of handling the first 3 or 4, whatever it is, agenda items on today's agenda? You're not going to get an objection typically if we do this the right way, and then you just proceed. At the bottom, you see there, it shouldn't be someone who's seeking the office. I do think that that's a little fishy. It looks like if we have somebody who wants to be chairing that initial part of the meeting, it kind of adds a flavor that, well, they're already in that seat. Why don't we keep him or her in that seat? And so I don't like that. Again, there's no statutory prohibition, but I don't think it looks the best. Jeff from Barron County, when he just notes that for what it's worth in Barron County, they have new board member training before the organizational meeting, so they get a flavor of what's going to happen at the organizational meeting. It works well for Barron County. I think if you have that opportunity, Jeff, and I think that speaks to the other items that you could have on the agenda for the organizational meeting, and we'll get into that in a little bit. But yeah, the more you can do in advance of that organizational meeting, the better. I think that's awesome. I think a lot of counties will tell you, we just don't have time. We can't put together all of the materials necessary to have this happen in an orderly fashion prior to the organizational meeting. But if you can, I think that's great.
Hey, Andy,
Go ahead.
question. Who do you see as the most frequent choice to chair these meetings?
It really varies. I can't say that there is a majority of counties that do it one way or the other. Personally, and perhaps this is showing my bias here a little bit, I like the corporation counsel doing it. The corporation counsel is the parliamentarian. They know parliamentary procedure. Nobody's going to trip them up on the process for nominations and voting and so on. So I like the corporation counsel doing it. That's my preference.
I usually see a county clerk do it. So that's interesting that we've seen it differently. I mean, I agree with you that the court counsel is, has that parliamentary experience. What are your thoughts on having the county administrator or the administrative coordinator do it?
I think that they can, but they serve in a different role. And when I say that, I mean, the administrator or administrative coordinator, or for that matter, county executive can chair that initial meeting. But remember, they aren't part of the legislative body, but they are attached to the legislative body because they're the administrative or executive arm of county government. So, I mean, given my preferences, I would not have them chair it, but there's nothing stopping them from chairing it if that's the best option. And Felicia notes that Milwaukee County Clerk does the organizational meeting. I think that's to your point, Rebecca. A lot of clerks, I've seen a lot of clerks chair that meeting and chair it very successfully and very well, and that's fine.
Yeah, this is one of the great things, again, going back to 5903, that counties really have the latitude to choose, what's best for your county, who do you want to chair, so.
So the nomination process, and I've seen this play out at different times in different circumstances in quite interesting ways. So let's just talk about Robert's rules as it relates to nominations. I don't have the Robert's rules sites on this slide, but this is basically all an encapsulation of the nomination process whenever we're going to have an election by the assembly. In this case, the assembly is a county board. So that temporary board chair declares the floor open for nominations. You don't have to be recognized to nominate somebody. You can shout from the floor, I nominate Rebecca Roger. In that case, Rebecca is nominated for that particular position. Now, as a matter of orderly procedure, would we like to see people being recognized if they're going to nominate somebody? Absolutely. Can you put in your board rules that somebody needs to be recognized in order to nominate somebody? 100%. You can do that. So again, might it be a helpful hint to put in your board rules the process for nominations? Yes, that's another topic for your board rules. Anyone can nominate. Any member of the board can nominate anybody else, and you can even nominate yourself. That's okay. There is no second that is required in order to nominate somebody, but there's nothing wrong with seconding a nomination in an effort to show the rest of the body that you support a particular candidate. So that's fine. Seconding speeches are allowed. Typically, a seconder of a motion is not allowed to speak as to why it is that he or she is seconding. But in this circumstance, again, under Robert's rules that can be modified by your board rules, you can provide a speech in support of you seconding a nomination. The chair needs to restate, and when I say chair, I mean that temporary chair should restate the name of the nominee so that that name is placed before the body for consideration when it comes election time. Nomination speeches are allowed, and I often get the question, okay, well, what about length of time for nomination speeches? What if the nominee wants to hand out pieces of paper? What if the nominee wants to give a PowerPoint presentation? Great questions. Robert's rules allows those things. Of course, the body can make a determination as to what they are going to allow or not allow. But again, should we have a provision within our board rules as to this process that speaks to distribution of literature, that speaks to presentation time limits, that speaks to PowerPoints? Yes, let's put that in our board rules so that we all understand that process. Technically, and again, this is Robert's rules, you can vote for whomever you want to vote for as long as that person is qualified to assume the position of board chair or vice chair or other officer, meaning that they have to be a member of the county board, but you can vote for whomever you want. A person does not have to be nominated in order to be voted for.
Andy, one comment I'll make here, potential issue, it's, I think human inclination that people want to talk beforehand, as to who may be interested in running for chair or vice chair. Always be wary, folks, of walking forums.
Yeah, we actually are going to specifically address that in just a moment. That's a good point. You're not required to have a motion to close nominations. That is certainly in order, assuming the chair recognizes the person and there are no other nominations that are forthcoming. A motion to close is in order, but you don't have to do that. The thing that I hear all the time are people ask 3 times, are there any other nominations? Are there any other nominations? Are there any other nominations? There is nothing in Robert's rules about asking that 3 times. I think that is just a historical practice where people do that in an effort to ensure that there are no other nominations, but understand that it's not required under Wisconsin statute or Robert's Rules of Order. If there are no other nominations that are forthcoming, the chair can declare the nominations closed. Here we have that question. Do the prohibitions surrounding walking quorum apply to politicking for the position of chair or vice chair? And I think they do. And I've gone back and forth in this over time because the question becomes under the showers test, if you meet the two elements, is there a sufficient number of persons necessary to direct county business? And is the purpose of having these discussions related to county business? Well, we're talking about leadership on the county board and in particular, perhaps an agenda as it relates to county board business. And so I think that you run the risk, if we have significant politicking prior to the meeting, we run the risk of establishing a potential for walking quorum. So all of that is to say is that let's give sufficient time for candidates to express their interest in a position and declare before the entire board their qualifications prior to the vote so that we don't have too much politicking that occurs before that organizational meeting. And so let's allow time for candidate speeches, allow time perhaps for the distribution of literature, allow time for a PowerPoint presentation if that's what we feel will give them an adequate opportunity to express their qualifications. Again, we can allow candidates to say a few words. I think that it's important to set that time limit beforehand, speak to this concept of distribution of literature or making a presentation. If there is only one nominee, the chair can accept a motion to close nominations and cast a unanimous ballot. I had the discussion with Sarah about this earlier this week about, well, can't the chair just on his or her own declare nominations closed and that the particular person is elected board chair? Robert's rules would allow that, but I think that's dangerous. The reason I think that's dangerous is because the statute specifically says that the board elects a board chair. Is it an election if the temporary chair declares nominations closed and awards the position, so to speak, to a particular person? I don't know. I don't know the answer to that. I'm saying let's not ever get to that question. Let's go through a process of if there's only one nominee, with the board's consent, you can declare nominations closed and cast a unanimous ballot. Then it's an election. Importantly, on the election of officers for the board, that is the only time that a secret ballot can be used. That's in 19.88 sub 1 of the statutes. In there it says, unless otherwise specifically provided by statutes, no secret ballot may be utilized to determine any election or decision except the election of the officers of that body in a meeting. So again, if we have board vice chair, and if the board rules provide for other officer positions, we can use a secret ballot. But as it relates to any other decision that we make, election of committee members, all of those things, if that's what your board rules provide as an election process, we cannot use a secret ballot. So then the question becomes, and I've had this come up as well, well, are the ballots that are intended to be secret, do those become public record after the meeting is over? That's a good question. And typically you go through the balancing test and weigh whether a particular requester could identify who's voting for whom on those ballots. You may make a decision that you release those. You may make a decision that you do not release those based upon the results of the balancing test. What I will tell you for every county clerk out there or board member that receives a records request for the ballots that were utilized in voting for the officers, if they were secret ballots voting for officers of the county board, speak with your corporation counsel. Please, please, please talk to your corporation counsel that before responding to a records request. Now, somebody has to count the ballots. Somebody has to figure out who the winner is, tally those up. And so the position of ballot clerk becomes incredibly important. We can tell you firsthand that we were involved in a gigantic dispute within a school board over the election of the school board president, because there were some not so good things that happened in the context of secret ballots and the counting of those ballots by a particular person who counted those ballots in the school board officer election. So it's really important that we appoint a trusted individual who is completely disinterested in the process to gather the ballots, tally the votes, and make declarations as to the outcome of those votes. It can be your county clerk. I think that is a natural for the county clerk. After all, The county clerk is the chief election administration official within the county under 59.23 of the statute. So if we entrust the county clerk to handle these gigantic elections, we can certainly trust the county clerk to handle these county board officer elections. So I think the county clerk is a natural fit. Can also be corporation counsel. It could, I've served as a ballot clerk when it comes to county board elections. So, I mean, it's really somebody who is disinterested in the outcome of the election and somebody that the board can trust. And so as a ballot clerk, they distribute, they collect, they count ballots, they report the vote. Again, we should have confidence of the board in that selected individual. This is important too when it comes to the elections, is that I've seen county board rules say that if we have 3 candidates for board chair on the first vote, if a majority of the board doesn't vote for one particular candidate, we take the candidate with the least amount of votes and take them off the next ballot. I think this is a mistake. I think it's a mistake because we don't know how subsequent votes are going to go. And ultimately, you may reach agreement as a board on a compromise candidate that may have been the lowest vote getter on the first ballot. We may have candidates that would draw from the race altogether following the first, second, or third round of voting. If we are unable to get to that majority, 51% or more of the board members agreeing on who the board chair or vice chair is going to be, it's important that we perhaps take a recess, allow everybody to take their breath. They have an opportunity to think about how they're going to vote, perhaps talk with a colleague or two, again, avoiding a walking quorum, but take that recess, gather ourselves, then come back and have the opportunity. Again, candidates could speak again, or we could go on with more voting. Again, whoever wins the board chair vote, they assume that chair for the balance of this organizational meeting. That temporary chair then exits off the seat, and that board chair that's elected assumes that seat for the rest of the meeting. Now, here we have a little bit more information on the impropriety of limiting the voting to the 2 leading candidates. I've seen it happen in counties where we get to multiple election rounds, multiple ballots. And at some point, people are going to be exasperated and say, we have to reach consensus on somebody. And sometimes the consensus that is reached is the person that one side really didn't want, or the person that the other side really didn't want, but the 2 sides were unable to agree on opposing views on their 2 selected candidates, so they choose the 3rd candidate. So I've seen that happen. And so again, that's why I think it's inappropriate to eliminate the bottom 2 vote getters from subsequent ballots for the position of board chair. Felicia asked, will the slide deck be shared with attendees? Yes, the slide deck and the recording will be at wicounties.org following our discussion here today. All right. So we started this discussion with the organizational meeting being a platform for 2 years of success. What does that mean? It means what you want it to mean. You have the ability to create a process and a foundation at the organizational meeting as to what you think is going to create success. And so looking at this, I was thinking when putting this slide together, I thought, what an incredibly daunting task to sit in that seat as a county board supervisor, having just been elected to represent many people. They've put their faith in you to represent them on the county board. And at that first meeting, you see on the agenda, there is a request from Human Services to transfer $250,000 from contingency to pay for an out-of-county placement. And I'm sorry, in normal everyday life, do we ever deal with out-of-county placements relating to human services departments? No, we don't. And so just having a fundamental understanding of what is being requested here, I think is a challenge. So the organizational meeting is an opportunity to educate new and, in many cases, existing board members about the functions within county government, because they are so varied. If you look at all the departments in county government, we got a sheriff's office to enforce laws. Highway department takes care of roads. Zoning department takes care of land use. Human services that takes care of human service needs. Social services. I mean, we continue on down the list, and all of those different departments serve so incredibly different functions. And so just trying to have a global understanding of all of the different functions of county government is an incredibly daunting task. And so the education can begin, and I know in Barron County, Jeff mentioned that it happens even before the organizational meeting. That's awesome. If we have time to get this done before the organizational meeting, that's awesome. And as you heard me say at the beginning of this presentation, if you need to continue the education process after the organizational meeting, that's awesome too. But I think many counties don't take advantage of the opportunity provided to have those educational sessions so that people have an understanding of how county government operates. All right. So the last bullet point is, in my mind, very important. We have to be thoughtful about our approach to the organizational meeting and our thought to the educational process for new and existing county board supervisors. This gets back to that whole process of establishing your agenda for the organizational meeting and carrying items of that agenda forward for the next couple of months to perhaps have additional discussions about education. I know that there is always a big rush to have a lot of training done right at the beginning of a supervisor's term. And I get that because we want people to have that level understanding. There is a really, really good resource that is out there. It's called COWS, County Officials Workshops. Sarah's in charge of that from a WCA perspective. It's prepared and presented in conjunction with UW Extension, but that provides a really solid foundation of how counties operate. And so I would really, really encourage you, when the information comes out about COWS training, really, really encourage you to tell all of your first-time supervisors at the least, and perhaps many of your existing supervisors, attend COWS training. Beyond the COWS training, there is additional opportunity. I've gone and talked to several county boards in the summer after an election, because it seems like in the summertime, it's a little bit more of a relaxed atmosphere. We don't have as much really, really urgent business to take care of. And again, I say that a bit tongue in cheek, because it's never like we don't have urgent business to take care of. But summer seems to be a more relaxed atmosphere to sit down and have a discussion about what does it mean to be a county board supervisor in X county? What do we do? The way we operate, why do we do it? What are our departments? Who are our constitutional officers? Let's have a discussion about what it is that we do. So again, it's up to you to define what that is, but take the opportunity now to start thinking about establishing that platform for success. Establishing expectations before the organizational meeting. In Barron County, they do a great job of that. But here's my question, or series of questions. Do you have a job description for county board supervisor? Do you have a strategic plan? Do you have an organizational chart that shows department and functions? Do you have county board rules? If you answered yes to one or more of those questions, here's my next follow-up. Do you distribute these materials to people who take out nomination papers? The answer I typically get back from counties is no, we don't want to scare anybody off. And I get that. And I know that no county board member out there is doing their job for the paycheck. I've seen what everybody gets paid. And I'll tell you, everybody's doing it because they love county government and they love their county. So I get that. But I do think if we have some of these materials distributed at the time people take out nomination papers, we certainly set expectations for when they assume the seat. And if we don't do it when they take out nomination papers, if we do it before the organizational meeting, at least we have that foundation of the expectations. And so let's think about the materials that we provide to our newly elected supervisors so that when they get to the organizational meeting, they at least have some base level understanding of what is expected of them. So again, all of this leads to a discussion of the planning and preparation that goes into that organizational meeting. There are a lot of areas for education. All right. And I don't think this list is comprehensive, and it's not intended to be comprehensive. There are things that you probably want to add to this list as well. But we can educate our board on county board rules. I think that's critical so that they have an understanding of the way things get done and how we govern ourselves. Roles and responsibilities within county government. I think you've heard me talk several times about the distinction between the legislative body and the administrative arm within county government and what that means. I will tell you that that is not generally known by members of the public. So a new supervisor does not have that foundational or fundamental understanding of the distinction in roles and responsibilities within county government. We could do some education on parliamentary procedure, open meetings law, public records law. And the last two I think are really important. I think if we engage with our department heads and our constitutional officers about what they do, why they do things certain ways, and how they view the role of their particular committee that they report to, or the board that they ask the board to appropriate money each and every year to support what it is they do, those are critically important discussions. And I don't think they happen enough. Let's set aside specific time so that the department heads and the constitutional officers can engage with the county board. I know years ago I was asked the question, well, what do you think about ride-alongs? If a supervisor were to ride along in the highway department, ride along in the sheriff's office and do that, I love the idea. I think a day in the life type presentation is awesome. But again, county government is multifaceted. And so I don't know how you get to all of the various functions within county government to do these ride-alongs or day in the life. That's not to say they shouldn't happen and they're not important and they're not good. They all are. If you can do them, awesome, do them. But if you can't get all of those on the calendar, a nice replacement is that discussion with your department heads and constitutional officers. Before I move on to resources, Rebecca, anything else you see in terms of education opportunity?
No, I think these are all really great ideas and obviously very important. My only follow-up comment on the, the day in the life, I love the ride-along idea, and what a great way for either a new or, existing county board member to really understand the business functions and the everyday function of those departments. However, I would just warn that we always have to be cognizant of supervisor having too much involvement in a particular department or with staff. And we see issues or questions from counties pretty frequently. There's a particular board supervisor who takes an interest in a particular department and is there a lot. And a day in the life experience could turn into something more. Again, find that healthy balance between making sure your supervisors understand the roles and the functions of different departments and so forth, but also making sure supervisors are cognizant of too much involvement.
Yeah, what I'm talking about are sanctioned, day in the life sanctioned ride-alongs. I think unsanctioned, where supervisors just stop by and say, I'm in a job shadow, presents problems. And that's where we get into the discussion of roles and responsibilities within county government. I think that's a good point, Rebecca.
Mm-hmm.
Mark Liberta from Walworth has a great point here, and I love this. Walworth County provides a 1.5-hour public meeting training session around the time that nomination papers are taken out. So anybody who wants to be a supervisor can understand what they're getting into, including handing out the job description. I love that. I think that's awesome. And I think, as I said before, many counties would say, no, we don't want to hand that out because then that discourages people from running. And that's a bit tongue in cheek. Then the supervisors who prevail in elections are given a longer private walkthrough of all those topics. I think that's awesome, Mark. And the more that counties can do that and set those expectations going in, it's not a guarantee of success, but I think it's a greater probability that success happens because everybody has an understanding of their expectations when they take their seat. There are plenty of education resources that you have. You have internal experts. Your administration, your department heads, your constitutional officers, your corporation counsel, they're going to be the experts on a lot of those education topics. And so they're going to be able to provide you with presentations, resources, and so on to assist with the education process. Then there are external experts that are out there as well. The Counties Association, they dedicate a lot of time to the process of educating county boards, county officials, others all around the state about roles and responsibilities, parliamentary procedure, open meetings, public records, other aspects of county government all throughout the state and all throughout the calendar. So lean on WCA for those resources. UW Extension has additional resources. I mentioned before the cows, the workshops. Sarah's going to provide more information on those in the coming months as we set the calendar for those workshops. But I think those are really, really good snapshots of a lot of the elements that we talk about as needed education for new supervisors. Other counties have great resources. We've seen it here today, whether it be Barron, Kenosha, Walworth, Milwaukee, other counties, they have great resources. What they do in order of establishing job descriptions, establishing education materials, and so on. lean on your county friends out there in Wisconsin and say, well, what is it that you do? And then steal, I'm going to use the word pejoratively, but steal from those other counties and create your own resources. And then finally, there is a law firm that I'm not going to name, but that law firm just happens to love working with counties and county boards. And that law firm, again, won't be named, but that law firm would love to help out counties more in that area. So with that, I think that we have hit the Q&A portion with 5 minutes to spare, unless Sarah wants to come back on camera and talk about anything that I may have missed. And Sarah's not coming back on camera. There she is. There's the camera star. Hey, Sarah.
Hi, Andy. Sorry for that little bit of a delay. I'm monitoring Q&A, participant list, chat.
I
all
was
of
just going to
that.
ask you,
For my-
did I plug your cows workshops well enough?
I think you did.
I think
you
those are
did.
awesome. Yes, I think those are awesome workshops. When are you going to set the dates for those so people can be
Yep.
on the
The
lookout?
dates are set. We were asked if I could put the cow schedule in the chat. I will mention that we did send out a constant contact with the dates and locations already.
Oh,
They
good.
are also included in our March magazine, which I just got in the last couple of days. So it should be entering your mailboxes soon. But since I will make a shameless plug while we wait for other questions to pop in. So the first cows, May 6th in Stevens Point, May 8th in Eau Claire, May 9th in Hayward, May 10th Minocqua, May 13th in Hubertus, May 15th in Green Bay, May 16th in Prairie du Chien. And then there's also a virtual option as well that will take place over 3 Mondays, June 3rd, June 10th, and June 17th. So if you can't get to your particular location, you will be able to join us virtually. You'll just have to do that over 3 Mondays.
Awesome. And so I think that you're going to have the information about cows up on the WCA website. Is that right, Sarah?
Yes, it'll be up on the WCA website. Registration will happen through the WCA website as well.
Awesome. So keep on the lookout for those. I think that we have cleared questions. I think that we've addressed things in chat. So let's leave this open for a couple of minutes so people can ask additional questions. Here
And
we've
you have a
got one.
question. You got a
What's the
question?
status of current supervisors and elected supervisors after April 2 and before April 16? So that's a great question because we had this question come up in 2020 with the pandemic when there was talk about postponing elections because the statutes weren't entirely clear on what happens there. And we were concerned that we may hit, if we postpone the election, we're going to hit a date where we don't have any county boards throughout the entire state, and that would be a disaster. We can't have those questions. And so the Supreme Court, and I don't have the case off the top of my head, but the Supreme Court said that the supervisors serve until a successor is elected and qualified. All right. So earlier in this conversation, remember we asked the question about what does it mean the first meeting after new supervisors are qualified? They're not qualified until they take the oath of office. And so it would be my impression that current supervisors serve until the successor is sworn on oath and takes the seat at the organizational meeting. So there is continuity. There is no breakage, so to speak, of a couple of weeks' time where we don't have a full county board. And so I think that the current board right now serves until the organizational meeting. And at that organizational meeting forward is when the new board takes effect, so to speak. That would be, again, piecing together case law, statute, and other sources. That would be the encapsulation of all of that is that current board until organizational meeting, new board thereafter. So I think we've addressed the questions. We've got a whole minute left.
I know, I was gonna say in the meantime, we might as well do another shameless plug for our March 27th in the boardroom.
March 27th in the boardroom, we've had some interesting things come up as it relates to public records and open meetings, especially in the digital age. And so we're going to do a deeper dive in open meetings and public records, dealing specifically with technology, because I would say that every month I've got a new interesting issue that comes up related to either public records law or open meetings law and the application of technology to those two sets of laws. And so we're going to do a bit deeper dive in March on open meetings and public records.
And Andy, though, during our previous in the boardroom regarding social media, and then also in our discussion at Ledge Exchange regarding social media, and lots of public records questions are intertwined with social media questions. So I think that's going to be part of our deeper dive too.
Agreed. Joe Cardamone just notes here, and he's correct. We have to address the possibility that a recount following the April election and the time to appeal the results of that recount to circuit court could prevent someone from being seated with the rest of the newly elected supervisors. Absolutely, Joe, that's right. All right, so we've hit the allotted time of 1 o'clock, Sarah. So at this point, are we thinking that we are going to close the discussion?
I move adjournment, Andy.
I don't need a motion because I can declare it adjourned. Are you
I
are
was
you
gonna
give me
say, if
that power?
you're gonna appoint yourself the chair of this, absolutely, you can declare us adjourned. And we will see everybody March 27th. Again, look for the slides and the recording on our website, wicounties.org.
Thank you, everybody. It was great talking with you about this really important topic. Look forward to seeing everybody in another month.
Bye, everyone.
Bye.